webinar on consumer data privacy. My name is Jackie Irwin, and I'm a member of the California State Assembly, and I will be your moderator today. I'm also a co-chair with Senator Thomas Alexander of South Carolina of the new NCSL Privacy Work Group, which is a subcommittee of the NCSL Cybersecurity Task Force. The work group was recently formed to examine policy issues related to consumer data privacy, algorithms and artificial intelligence, government data usage, transparency, and other issues, as well as to consider the intersections between data privacy and cybersecurity. This webinar is part of Privacy Week at NCSL, during which you will see a focus on privacy issues in NCSL blog posts, web pages, and a podcast. We are grateful to our Privacy Work Group sponsors for their support of these activities. You can read more about them by selecting the tab at the top of your screen labeled Resources. So for some housekeeping notes, before I introduce our speakers, I'll go over a few housekeeping items. One of our goals today is to have an interactive discussion with you, our audience. Over the next 60 minutes, we encourage your participation, so please feel free to type your questions in the chat box, which is at the lower left-hand side of your screen. Your questions in the chat box will be visible to all attendees. To begin building comfort with the chat function and to learn who is online today, I invite you to type in the state from which you are calling right now. At the end of the presentation, we will address questions from this chat box. To address one question you may have, this webinar is being recorded and will be made available on the NCSL website within about a week. With that, we turn to our topic of the day. State legislatures have passed many different types of privacy laws over the years. However, California's Consumer Privacy Act, which passed in 2018 went into effect in January this year, is the first state-level comprehensive privacy law in the United States. As the California law enters implementation phase, we will look at its impact and the outlook for future privacy legislation in California and other states. We will also explore evolving public perceptions about privacy. We are pleased to have with us here today Lee Rainey from Pew Research and Christopher Yu from University of Pennsylvania Carey Law School. Our third speaker, Stacy Schesser from the Office of the Attorney General in California, had an unexpected conflict, but will try to join us later if she is able to. I encourage you to read our speakers' bios, which can be found in the tab at the top of your screen labeled Speaker. You can access the speaker information and other resources at any time during the webinar. We will first hear from Lee Rainey. Lee is the Director of Internet and Technology Research at Pew Research Center. Under his leadership, the center has issued more than 650 reports based on surveys that examine people's online activities and the role of the internet in their lives. Thank you so much for joining us today, Lee.
Thank you, Jackie. It's a real honor to be talking about our longstanding work related to American attitudes about privacy. My part of the Pew Research Center has been in business for 20 years, and the second survey we ever did related to privacy. And it's really an issue that the internet has sort of brought back to the top of the agenda for many Americans. So I'm going to go through some of the big findings that we had in a survey that we did in the middle of 2019. So these are pre-COVID findings in many cases, although I will be sharing some pandemic era data with you as well. But it speaks to the sort of broad patterns of beliefs and worries that Americans have when they think about privacy. So in this survey, we asked a variety of questions about people's views about privacy, both in the context of what companies are doing as well as what the government is doing. And the basic headline was that Americans are confused, they are concerned, and they feel like they are not in control of their own data and their own destiny when it comes to privacy. These are concerns that have been elevating over time, as well as the the worries that Americans have about the data that they're going to be getting. So you can see here that when it comes to people having a sense that they have little or no control over their data, 81% of Americans say that applies to the data collected by companies. 84% of Americans say that applies to data collected and surveilled by the government. They think that the risks of collecting data and being monitored and tracked in a variety of ways outweigh the benefits of those data. So in almost all cases, the data is being collected for some purpose, either by the companies for understanding their users, selling ads and things like that, and for the government for protecting people, and in the case of the pandemic, understanding who might have been exposed to disease. But in the broad sense of whether Americans think the trade-off is worth it, they're saying the risks outweigh the benefits, both on the side of company collecting data and government collecting data. They're also concerned about what happens to the data once it is collected. 79% say that they are concerned when it comes to the data collected by companies, and about 2/3, 64%, say they are concerned about the data collected by government, and they don't know what's done with it. So 59% say they have very little or no understanding about what happens to their data when it's collected by companies, and 78% say that when it comes to the government. They also have a sense that their data is more in peril now than it used to be. So we asked a question about, do you think your data is as safe or not compared with 5 years ago? And 70% of Americans said that they felt their data was less secure now than 5 years ago. It's pretty across the board. So we break out some of the demographics here, but you see that people who are older are somewhat more concerned than people who are younger. White Americans are somewhat more concerned than Black Americans and Hispanics. There are people who have higher levels of education and higher levels of household income also have somewhat higher concerns than people who are at the other end of those spectrums. And there's a sense that surveillance and being observed is an omnipresent part of life. And so this is a slide that shows that 7 in 10 Americans think all or most of what they do online is tracked by companies, and about half say that when it comes to the government. We asked a similar question about what are they doing when you're offline, and people don't have necessarily the sense that they're being tracked in the same way offline as they are online. But there's a sense when you talk to people, particularly in focus groups, this is something that they know is an important part of life. And in many cases, about 2/3 of Americans say it's almost impossible, if not entirely impossible, to be anonymous at any significant period of time in your life. The other thing that goes along with that finding related to people being concerned about their data being less secure is they don't think that the companies are very transparent about what happens. So 79% of Americans say either they are not to or not at all convinced that the companies will publicly admit mistakes and take responsibility for misuse of their data. So there's a sense that they just are not made aware when bad things happen. That they similarly are not convinced that the companies will be held accountable by the government if there's misuse of data. They are not sure that companies use data and personal information in ways that they would feel comfortable with if they knew about it. This is the consumer view of it. And they are not sure about 2/3 say they are not to or not at all sure that they would be promptly notified if something with their data were misused or somehow compromised. So again, there's a sense that you're always under surveillance, and there's a sense that the data that are being collected are vulnerable in quite important ways. But then you ask the other side of the question, okay, there are policies and practices and laws in place to allow people to get notified and to consent to the processes going on. So we asked a series of questions about what Americans do when they encounter the privacy policies that they're often asked to read before they venture into websites or other applications. And only about 1 in 5 Americans say they always or often read the privacy policies before they agree with them. And a minority of Americans who read the privacy policies say that they read them all the way through. So even the people who open up those policies and scroll through them are not giving them a very serious going over. So, you can see there, only about 1 in 10 Americans say they always read privacy policies before agreeing to the terms and conditions that they sign up for. And another 13% say they do this often. So 1 in 5 are sort of vigilant in ways that the system allows them to be. And they are also pretty interested in one of the interesting things that came out of the GDPR in Europe and then the California privacy law. They would like the possibility of the right to be forgotten and to keep information from being searchable online. 74% of Americans say they would like to keep things about themselves that might be damaging from being searchable online, which is essentially the right to be forgotten, at least in the European sense of the term. And they would like the ability to remove or limit access to potentially embarrassing photos and videos of themselves, information about their employment history, negative media coverage that might have occurred about things that have happened in their lives, and the data that law enforcement have collected in their encounters with the police. These are particularly high concerns, as you'll see in that dot plot chart on the right, for older Americans. But there are also ways in which, there's clearly a transactional kind of engagement that people have with data collection. So we asked Americans about trade-offs. How would they feel about the use of data under certain circumstances? And there are ways in which at least pretty decent pluralities of Americans would find it acceptable, for instance, if poorly performing schools shared student data with a nonprofit organization seeking to improve the educational outcomes at the school. So about half say that would be acceptable, about 27% say that would not be acceptable, and the rest say they're not sure. Similarly, Americans are more comfortable than not with the idea that the government collecting data about Americans to assess potential terrorist threats. Similarly, DNA testing companies sharing their data with law enforcement authorities in order to solve crimes. But then things sort of change, and this speaks to the sort of transactional and contingent nature of the way Americans think about privacy. They really want to evaluate the particular circumstances of data sharing or data analysis rather than saying, I want everything to be private or I want everything to be public. There are very sort of nuanced views related to this. So about 41% of Americans find it acceptable that fitness tracking apps make user data available to medical researchers. 35% say that they would find that not acceptable. And then you get down to a situation where more Americans than not would say it's not acceptable for social media companies to monitor users' posts for signs of depression, or smart speaker makers sharing user audio recordings with law enforcement authority when they are trying to solve crimes. And most Americans think there should be more regulation. We can probably, Christopher has some ideas, I'm sure, about sort of what direction policymaking might go here. But at least in the broad sense, Americans like the idea that there would be more regulation of the way things are happening, particularly what happens to data after it gets collected. But again, sort of a very typical American answer here. When you ask them about the trade-off, which do you think would be better, the most effective way to safeguard people's data, 55% say Americans say better tools for allowing people to control their personal information would be the thing that would be the most effective, while 44% say stronger laws governing these companies. So there's a way in which Americans sort of want to recapture control of this. And then we asked about things related to digital contact tracing in relation to the coronavirus. And most Americans don't think that digital tracking will help. We asked this question early on in April when there was a lot of excitement about Google and Apple getting together and making a contact tracing app that would use Bluetooth technologies. But Americans were not convinced that that would make much of a difference in limiting the spread of the coronavirus. And then here, again, sort of trade-off questions that are so, sort of hard for policymakers to figure out, because different people give different answers depending on the circumstances that they're going through, and it's just not a sort of clean, linear story about what Americans want. So, more people than not, just a little bit, say that it would be acceptable for digital cell phone apps to be used for finding those who have tested positive in the coronavirus in order to understand how the virus is spreading. But then they're not as comfortable with the idea that the people who might have been in contact with somebody else are monitored through cell phone digital apps. And they're not at all comfortable, 62% to 37%, for using digital contact tracing to ensure that people are complying with expert advice to do social distancing and other protective measures. And you can see that different groups in this slide have sort of different views. Hispanics are more likely to be open to data sharing and digital monitoring. And so that adds another complexity to the story. It's, again, not a uniform thing across the population that people are open to these sharing ideas. And with that, Jackie, I'm going to turn it back to you.
All right. Thank you so much for that very interesting presentation. And next up, we have Christopher Yu. He is the John Chestnut Professor of Law, Communication, and Computer and Information Science. He also serves as the Director of the Center for Technology, Innovation, and Competition at the University of Pennsylvania. His major research projects include studying innovative ways to connect more people to the internet, using technological principles to inform how the law can promote optimal interoperability, and protecting privacy and security for autonomous vehicles, medical devices, and the internet's routing architecture, among other issues. Welcome, Professor Yu.
Well, thank you very much, Jackie, and thank you to the entire NCSL for allowing me the chance to speak here. I'm delighted to be part of Privacy Week. It's an important, a new initiative that I think that you are undertaking, and this new committee, I think, will contribute a great deal to the public and to the welfare of the people which you are also dedicated to serve. I'm delighted to be here with Lee, in particular, whose work I rely on when I teach privacy and when I'm doing work for the American Law ALI Institute in different privacy projects as an advisor. And I'm delighted, hopefully, to see Stacy, because I think that California has done yeoman's work in taking the lead, being one of the first jurisdictions to explore the different issues. So I would like to try to emphasize three basic points in the remarks I make today. And just to give an overview is, one is that I'd like to underscore the importance of taking a consumer focus in any interventions that states undertake to protect privacy and to regulate privacy. And of course, I'll spend some time talking about what I think taking a consumer focus means. I'd like to also discuss some of the implications of existing privacy regimes have had for small businesses and for competition more generally, and to talk about operationalizing what privacy regulations actually impact they have for different businesses and they operate. And lastly is to offer some speculations about future directions technologically that might affect the privacy space. I have to say speculations because if there were predictions, I'd be rich sitting on a beach someplace and enjoying myself. It's one of these things where predictions in this space are all hopefully, more often than not wrong, but hopefully at least interesting food for thought. So taking these one at a time, in terms of focusing on how to best protect consumers, many privacy regimes treat all what they call personal information or personally identifiable information the same. And one of the slides that Lee presented, which I find always fascinating, really underscores that consumers really regard different aspects of privacy or privacy with respect to different spheres of their lives very differently. So in many cases, he found in the slide he presented is they found sharing for education, certain purposes were more permissible than not, but sharing for digital personal assistance would be less so. And it's fascinating that what you start to see is one of the things that he found acceptable in that survey most recently is the use of surveillance for terrorism. And I would say that there is a difference in different realms. There's another study of his that I'll cite where we found that one of the most acceptable ones in a 2016 study that Lee read was offer surveillance and facial recognition technology to identify office theft was okay, but the most problematic one was monitoring smart thermostats. And so it's fascinating to me because there's a variation, and I usually teach my class, I give the students these different alternatives, And their priors about what people are going to think vary widely. And so what we discover is there's a huge range. But also the fact that this is likely to change over time. I was fascinated by Lee's terrorism point. My guess is our views of what's acceptable in terms of terrorism monitoring is different post and pre 9/11. And that there are different things that happen. You know, I know, for example, I have friends who live in Israel where they recognize their expectations for privacy are much lower, simply because their perception of their national security risk is much higher. And so what we see is this range of possible things that suggest being more context specific instead of treating all personal information the same. And what we also find at the same time is that consumers are benefiting enormously from many routine uses of personal information. Now, the most important of which, oddly enough, is the use for advertising. So consumers love free. And and we learned a long time ago that old free television that we all grew up on once upon a time wasn't free. It was advertising supported. And there's a direct relationship between the amount of revenue generated by the advertisements, the amount of it you get, and the quality of the programming you get. And as long as we're going to hold that as an option, that's going to be a major dimension that any privacy regulation has to take into account. There's a great study by Catherine Tucker at MIT and Anya Lambrecht at London Business School that looks at the implementation of GDPR. The 1995 Data Protection Directive. And they studied its impact that the privacy regulations had on the effectiveness of advertising. And they discovered that it dropped the incentive to buy, the effectiveness of the advertising by about 2/3. Now, that may be an acceptable trade-off, but I guess some people suggest the trade-off doesn't exist. And the limitations on the uses of privacy are in an advertising-supported world are going to show up in less revenue for the advertisers and the apps, which means fewer of them. The break-even point gets higher, which will reduce their diversity. And there's a number of inevitable problems that go along with that. On a more immediate basis, or COVID-19 has really put forth the importance of being more flexible about this. So GDPR has had to put through some enormous waivers and different things to allow information sharing for contact tracing, but also for therapeutic reasons, for finding what works, and move healthcare information, which is really sensitive, around. And another great example is both California and to some extent GDPR focus on not just information about individuals, but information about devices. And so a good example of that is a phone number is a unique identifier for a device. An IP address is a unique identifier for a device. And unfortunately, the interpretations of some of these rules cause certain basic functions that we rely on to find people to break. The who-is function broke under GDPR. And I remember under the FCC, they stated with great pride during the few years they were enforcing privacy about restricting information about sharing of phone numbers at a time where many consumers, I'm personally listed in the proverbial phone book, although the physical books don't exist anymore. My phone information is public information. And a regime in which you have people protected or not protected is probably more effective than having a world where we say, oh, we know how all this is going to work in a particular way. And I would also say is there's not just current uses, but future uses. Things like innovations like Google Translator are built by correlating two sets of data which were not collected for the purpose of translation and for yielding different things. And this has been the story of a lot of this kind of innovation, and drawing the lines of when those benefits exceed the potential costs becomes one of the great challenges of working here. The other thing I find not consumer focused about some of the legislation is some of it focuses on particular actors in the entire universe. What you'll find is that any digital service requires a device manufacturer, an operating service provider, a service aggregators, a network provider, and they all have different levels of access to your data, whether it's the apps themselves, the windows or the browsers, the operating systems, they all get different amounts. And what I discover is consumers don't really care who's getting what. They just care about everyone who gets access to their personal information. And I can see doing individual specific levels that are appropriate for each one, but then you can create these weird perverse incentives where you say, well, if this one's regulated more than this level, let's move things around. And second, it creates very difficult definitional problems. So what I would really think is that, the FTC's approach in different places and historically embedded in the US approach of sector-specific privacy regulation is an appreciation that with different contexts, different sets of rules matter different ways. And that, in fact, we have, I've seen a bunch of, and that, in fact, many of the so-called basic measurements or components of a privacy regime often, in many contexts, aren't benefiting anybody. So the Privacy Bill of Rights is often used as a yardstick. Another very common thing is the Fair Information Policy Privacy Practices published by the HEW in 1973. And the political empirical study shows that some of those provisions, which are sort of saying, well, if you have this, you're a good privacy policy. If you don't have it, you're a bad privacy policy, have never been validated. And I've done a little validation with some individual providers. There's one requirement of FIPS that is embedded in HIPAA, the healthcare privacy federal statute, that says if you should be able to ask someone who has your data, to whom have you given my data? And you find that that actually is done a vanishingly small amount of times and is generating large compliance costs, which is something I'd like to talk about in a minute. There's a question about whether, okay, do people just not know about it? It's quite possible that this is a rule that isn't actually benefiting consumers. When the President's Civil Liberties Oversight Board looked at a number of surveillance practices for national security, they actually did an empirical analysis and said, this provision is actually working, let's keep it. But they said, this provision is not actually catching anybody and it's just an invasion of people's privacy, let's get rid of it. This sort of pragmatic idea, I think that this is an interesting balance, a way to think about it. So moving from the idea of different context specificity, let's talk about the impacts on small businesses and on competition. So what's interesting is the compliance cost estimates for CCPA are roughly, I've seen one published estimate as at 1.8% of GDP. And that's an interesting number. It's just one estimate, but there's no question that there's going to be some impact. There's another fascinating study of GDPR that looks at venture capital funding that believes it had reduced the number of deals by 17% and it reduced the amount raised per round of VC funding by 39%. And that, in fact, that you start to see certain business models being cut off by it in the VC side. But on the compliance, the cost side for small businesses, what you see the big change wrought by CCPA is there are industries who were heavily regulated before and had compliance apparatuses already set up. That healthcare, financial services, different regimes, education, who are already regulated. There are a large number of industries who have never had any significant privacy regulation on them. And what you discover is privacy regulation is really driven by, the business end of this is compliance by the companies. What anyone who does privacy will tell you is that unless you can document it, it didn't happen from a legal standpoint. And so what you discover is to do a proper regime, you've got to train your people on what they need to do. You have to create tracking documentation to make sure they're implementing it properly. You have to do periodic checks to make sure they haven't just been done it, you haven't just told them to do it, that they're actually doing it. And that, in fact, all this takes time and effort, a fair amount. And in fact, I was just doing a project for the Administrative Conference in the US, where he's talked about privacy trainings, and every agency person in the room sort of rolled their eyes and groaned. And I understand that, and I appreciate that, but that is the side effect of having to do all the compliance. And what's really interesting is having to create those structures for the first time is very challenging. The other thing that's really important to focus on about compliance is you have to ask yourself what a privacy regime is designed to do. Is it designed to stop the problem from happening in the future, or is it about a compensation regime? For example, HIPAA is a compliance regime. They do not have a private cause of action. They do not generally assess huge fines. What they do is they find a problem, they work with the covered entity to make sure to help fix the problem. And as long as they're actually actively working to find the solution, the fines are fairly minimal, because the purpose was not to take money out of them. The purpose was to fix the problem. And what you'll discover is, I think this is embedded, for example, in the cure regime that the California CCPA allows, that the proposed California Privacy Rights Act would get rid of. And it's a different approach when you think about how we're going to make this work. And it's especially hard in privacy, because if you generally go to a compensation regime, we generally require proof of economic injury. And anyone who's looked at the cases here recognizes that's extremely hard to do. And that in many ways, also, if you make it about compensation, you get less the behavior that some of the behavior Lee talked about companies not being forthcoming. Compliance regimes about fixing the problem tend to induce companies to be more forthcoming faster with information, because what's at stake is improving a practice that's a vulnerability as opposed to exposing them to liability. And so it's an interesting question about the goals. If your goals are to fix problems as quickly as possible, these sorts of compliance-oriented regimes can actually be much more effective than liability-oriented regimes. The other interesting thing about the side effect of the costs of this of compliance regimes, though, is these burdens are fall much heavier as a percentage-wise basis on smaller and medium-sized firms. And there is some evidence that, in fact, that this is actually reducing their ability to compete. In addition, when you notice the CCPA, a lot of it is about data transfer, which is moving from one organization to another. To the extent to which a company collects information by itself and uses it itself, it's largely unaffected by that restriction. That restriction does fall heavily on data brokers in that industry, which is what small businesses have relied on. And understanding how these dynamics play out in the real term has been an interesting lesson coming out of CCPA. All right, and GDPR. The last big point I wanted to make, future tech. One of the interesting questions is, on the positive side is, if I had to guess, there's going to be a lot more future innovation. And what's fascinating to me about this is a lot of the focus, both in GDPR and the proposed CPRA, is about automatic processing. I will tell you, most of the innovations we've seen in the high-tech world involve some form of automatic processing. That's how we achieve scale. That's how we're able to grind through all this information so quickly. And putting limits on that would curtail the ability for people to explore certain types of solutions, which to date have yielded tremendous benefits. I mentioned examples of Google Translator. There's always unanticipated uses of data where you can use them in ways that can benefit people. And the problem is there's also uses of them that can actually hurt consumers and hurt citizens. And finding the filters to draw those lines in a way that balance those concerns properly is one of the big challenges. The second big prediction I'd make about future tech is, to some extent, on a self-help basis, you're going to see a lot of closing up of the privacy space, particularly by the use of encryption. You see a lot of fights about this, where people will, if you encrypt the data flow, then only people who can start to see it are the people, the intermediaries lose the ability to see it, and only the people who are the source of the data and the recipients of the data tend to be able to see it. And then we see a sort of a different world. What we're seeing, it's interesting, is a fight then, it's not so much a net change in privacy, but a redistribution of who has access to information in ways that I think are particularly, that could create winners and losers, and that can be affected directly by the way states intervene. And what I would say, though, is we're actually becoming much more adept on using data. One of the interesting things, we used to just look at what we called structured data by looking at the categories they actually collected. We're now able to use unstructured data in ways to infer things from categories that aren't in the data, but they say, oh, if based on all this, we can make a guess about these people, about certain qualities that they have. And that's made it much more sophisticated and much more complicated, but actually has yielded tremendous potential benefits to consumers. And figuring out ways to regulate this and in ways that make sure we preserve the innovative world while protecting consumers is the enormous challenge that's going to be, frankly, with an innovative world, a moving target. And that tells us that we have to create a regime that's supple enough and flexible enough to be able to accommodate the future, because the one thing we know is that any predictions we make right now, even if they happen to be right today, will be changing very, very quickly. And with that, I think that's my 15 minutes. I'm delighted again to be here, and I look forward to your questions.
All right. Well, thank you very much, Dr. Yu. Are we up here? No? All right. There's a lot of interesting points that you raised there, and I think one of the big things when you're talking about consumers is, you look at the surveys, everybody's very concerned with privacy, but then it depends on how much convenience they have to trade off for that, and a lot of things just, the maps figuring out where you're where you're probably going, or figuring out how to you're doing a text message and all of a sudden it shows up on an event shows up on your calendar. Those are things that we've really gotten used to. And the one other thing I would say is that we are seeing now in California, almost everything that pops up, there's a disclosure and you have to allow yourself to be tracked. Well, it gets to a certain point that everybody just is clicking yes and they're not reading anything anymore. So there is a we have to watch for that issue of every part of the regime that we put in place when there's too much that people are not actually gaining any privacy. But I think the most important thing of all that you said is that we need to make sure that the regime is flexible enough to accommodate innovation. That is that's a big concern, and in California, we don't know yet if we have the right balance. So I just want to remind everybody to put your questions in the chat box. And I'll start with the first one. We're going to have a couple and then go to the audience. Pew's research shows us that much of the concern around privacy revolves around consumers' control of their data. What should legislators keep in mind when considering opt-in versus opt-out requirements or other proposals to address issues of data control?
You wish that they would give a simple answer on that. And when you ask that question that way, they would say they would prefer an opt-in system. In other words, they have more control at the starting point if they get to choose what they buy into and what they don't. And yet, just as you pointed out, Jackie, all of the convenience that's baked into these products is stuff that the more they use it, the more they embrace it and are satisfied with it. And so it's an abstract concern that they have more than a sort of everyday life level concern. And it just, you can't underscore the point enough to sort of say that privacy is such a difficult subject because there's such contingency baked into it. It depends on what transaction you're asking about, what the value proposition is, who is asking for it, because different companies and different individuals or institutions are scored as more reliable and more trustworthy, as opposed to places where the data might be breached. And so it just, it's a moving and very fluid situation where the consumers don't draw the kind of bright lines that you just described and the kind of and give a lot of guidance about where they would love the world to end up.
So if I may chime in as well, I think Lee's got it right. And to try to put a sharp point on this is many people voluntarily give up their private information under certain circumstances and knowingly. So the example I used to give to my students that's actually been, rendered is obsolete. I used to be able to have two choices. I could get the New York Times delivered to my doorstep in print for once every day for a month at $30 a month. Or I can get it for free if they could put cookies on my browser. Now, to put it in a little bit more concrete context, AT&T has a fiber product, which they will sell it to you for the standard monthly fee. But if you let them monitor your data, they'll give you like a 20% discount. And the take rate on that, I think, is extremely high. And so what you see is people find that is a different commodity that they can pay for that's different from cash. And the question we have to ask as regulators is, do we want to foreclose one business model? Do we want to make that alternative off the table? We assume, oh, maybe they don't know, then that's easily cured. You inform them what's going on. And the problem is, even if they're fully informed, if you don't want to do it, it means to say, I'm sorry, you think it's good for you. We don't want you. That's not legitimate. And as we talked about before, that may not be the same uniformly with respect to all categories of personal information. So, I mean, this is what makes the nuance on this so difficult. I want to pick up on one thing Jackie said in the intro about surveys, which is I think the work, as I said before, I rely on Lee's work. I think the work Pew does is fantastic. There are other surveys. I know that at the same time, the Federal Trade Commission's Bureau of Economics, and the FTC being the primary federal enforcer of much of the federal privacy law, has a lot of distrust of a certain type of survey research, which is, on a scale of 1 to 10, how important is privacy to you? And use the high numbers to demonstrate things. That's a classic example of a demand effect, which is by framing the question in that way, it's going to be very, very hard to get an accurate result. And what you see is in people's revealed behavior, people give away their privacy for a $1 discount at their grocery store for a coupon, and on the loyalty programs. And you'll discover that the revealed behavior suggests their value of privacy is quite low. And we have to unpack the question, is it because they don't understand the extent of what they're giving up? Or there's another possibility which you have to entertain, which is that's real value to consumers that they're able to obtain by exchanging a different commodity, and trying to figure out how to get our minds around that is one of the great problems we face.
This is just an audience question clarification for Lee. Did the survey ask respondents how long data is retained?
We've asked separately about that, yes, and as a general rule, Americans would like minimal data retention, and part of this sort of spirit of protecting and giving me control over my data and things like that. But there was a comment just after it that David Foy made that was really interesting and important, and we've asked these much more transactional and contingent kinds of questions. And when you pose a very stark trade-off, your data are going to be deleted, and you don't have to worry about it again. But by the way, when you've got a consumer complaint to lodge about a previous transaction, or when you want to retrieve something that was important for your own personal records, Americans want that too. So that the deeply frustrating part of this is that they want it both ways. They want to control it when they want to control it, and they want to take advantage of its sharing when it's to their advantage.
And actually, European regulators have had to confront this exact problem. They have the rule I mentioned earlier, which is you have to be able to ask anyone who has your data, who have you given it to? Well, someone asked that. They said, well, we can't tell you. We've deleted that already. And so the GDPR has now created a rule. Well, you can't do it. You have to hold it for some amount of time. And the regulated entities say, how long? And the answer is, well, we're not going to tell you that. We don't know exactly how long, but it's pretty clear you have to hold it for at least a year based on the existing rulings. And you may have to do it for longer. A lot of privacy advocates have wondered, would consumers be better served by, instead of requiring all these people to hold this data for a year, that it simply be deleted in a shorter amount of time than that? And one of the things I'm looking at in contact tracing, given that the data about contact tracing is about recent contact with infected people, we can actually shorten this to as little as 2 weeks, because beyond that, it's not really useful, but it might be useful for other purposes about therapeutic analysis and all this. And we have this huge trouble we were doing. But there's a good example. But for other reasons, we can go with anonymized data and other forms of data where it's just not that important, where you don't have to have it per se identifiable, and we can start to zero in on the exact problems.
Yeah, it is, as you go deeper into it, you do see that none of these answers are really that easy. And yet some of the questions, like who did you give the data to, that's where you see the most egregious abuse. Last year, we looked at cell phone companies who had sold data to data brokers. And that basically meant that your ex-husband who beat you could be following you around real time. So then you see a real egregious example of this is exactly the type of person that you didn't want your data to go to, because it's not benefiting you in any way. Now the telecom companies say they're not going to do that anymore, but I think need to stay on them. So Congress has released a number of federal privacy proposals, most recently the Safe Data Act from the Senate Republicans, which would allow courts to order injunctive relief to force companies to obey privacy laws. Can you talk about why the method of enforcement is important when regulating privacy? And I know that you've gone into this a little bit, but I think it's definitely a point to emphasize.
Well,
let's start with you, Christopher.
All right, thank you. I'm happy to. So injunctive relief is a classic example of a compliance regime as opposed to a compensation regime, which is, you have a practice, you're trying to fix it and trying to stop it from happening. And in fact, so the analogy I always think of is cars and products liability. To some extent, originally the tort regime was about compensating people for being harmed for wrongdoing, but it evolved into this compensation regime where they're saying, okay, we're going to use this to engineer safer cars by penalizing some people higher with, excessive damages or, these sorts of things, or damages that are exemplary damages and the like. And the problem with that is it creates all kinds of weird phenomena, which is, for example, a person who's injured may be overcompensated or undercompensated because the actual level of compensation had nothing to do with their injuries. It had to do with creating incentives for people to change their behavior. The alternative to this would be automotive safety regulation. Determine what a properly designed car looks like, make people meet it, create sort of regulatory fines. But there, it's not backward looking, it's forward looking. It's about creating new cars safe and making cars safer in the future and avoiding future accidents than it is to be backwards looking. And particularly if your goals are not about compensation, but about making the world safer, doing it through private rights of action, all that creates it's a strange way to do it. It trails the actual injury. And in the classic words of Jeremy Bentham, you sort of train people the way you train a dog not to pee. You wait for it to make a mistake, and then you whack them over the head a bunch of times, and after a while they figure out, oh, I shouldn't be doing that. There's a lot more. The regimes before that lay out clearer expectations and guidance and have people conform to that, and then have regimes that are closer, I think, are better. I'm actually fascinated by the California regime that doesn't create a general private right of action, but does specifically for data breaches and for specifically a particular kind of thing where perhaps there might be more culpability, arguably, on the part of the person who let the data go. But finding the actual goals you're trying to solve and creating remedies that are tailored to them that are actually designed to address the problem you're trying to solve is an essential part of designing a proper regime. And that the other, I think I will say, and this is an issue that I think all state legislators have to consider too, which is you also have to have an adequately staffed and funded enforcement regime. Because if you're going to do this, it's going to be very, very difficult to respond to all the consumer complaints in a timely way. And there is a financial commitment that has to be made by a state hand in hand with the implementation of any regime, or a federal government. The federal government's actually quite concerned. Even the FTC have said they have one administrative law judge. They have, a staff that's, just not in a position to handle certain things. And that would, any expansion of any agency's authority in this requires a commensurate increase in their funding.
All right. I don't know if you have anything to add to that.
If there's a question to answer, let's go to the next question.
Okay. I just want to remind the audience that if you have a question, please put it into the chat box. We want to make sure that all your questions are answered. Many people think of consumer data privacy in relation to their data being sold, but privacy issues show up in a lot of other interesting areas like genetic testing, fitness trackers, security systems, and transportation apps. What are some privacy issues that might not be on legislators' radars? And the genetic testing has been so interesting over the last couple of years. The number of old murders that have been solved is really quite incredible. I did hear a story about a friend of mine who did a genetic testing app, and his brother was sitting across from him, and they both looked up their relatives, and it turned out, oh, that's only my half brother. Yeah, so there are a lot of issues there, and in California we did. I don't know what happened. I'm not sure if the bill is going to be signed or not, but we started to delve into genetic testing. But what else should we have on our radars?
Well, everything's going to get smart sooner or later, which means that it's a data collection, data surveillance, or data transmitting entity or artifact or sort of piece of the world. And so, where you go, who you're with, what's going on in your body. Some of the most interesting applications of facial recognition now are to read people's emotional states and try to either commercially intervene in those states. Go get a cup of coffee if you're getting drowsy, or if you're feeling depressed, why don't you have here's a bar where you can get a happy hours underway. So that sort of almost all dimensions of life are going to be implicated in these ways. So basic elements of human behavior, and I think that's the part that Americans can sort of see the end game of that, and that is a sort of almost existential kind of worry that they have, that they will lose autonomy as well as sort of the right to make decisions about themselves and their data. They also worry that you're going to get already there's evidence of a sort of a class structure on this, that the better off people will be able to purchase their way into the sort of information environments that they want to be in and the privacy they want to have. And a lot of other people, in part because they've signed under the systems Christopher was describing, won't have that privilege and won't be able to have the same kind of autonomy that they're better off and better resourced and maybe better networked fellow citizens have. So there isn't any dimension of life that I can think of that in the next 10 years is not going to be part of the data ecosystem and therefore part of the privacy conversation.
Well, I think that's absolutely correct. I mean, beyond the economic worlds, I mean, and for example, Jackie, you mentioned law enforcement, and you're in the place where the Golden State Killer was just nailed, just one of the great unsolved crimes of your state's history. But it's beyond that. I mean, one of the very more interesting controversies, for example, of a couple decades ago is the use of federal tax return data to catch deadbeat dads, under state, family law. And, it's an interesting question. I think most people, our gut reaction to that is, well, if there's someone that's not complying with their obligations, using other pieces of data to catch them, to hold them responsible and held up their responsibilities, their end of what they're supposed to be doing, it's probably a good thing. On the other hand, would we feel comfortable allowing them to use an unlimited number of data to do anything just because it's in the name of law enforcement? Some people have different sensibilities about national security and the like. In addition, education. Understand using data to tailor individualized plans to students is a tremendous promise. I mean, look, I've been a high school teacher before I went to law school and became a university teacher. The ideal would to create a customized learning plan for every student to meet them exactly where they are. The reality is most teachers don't have the chance to do it. Ed tech can do this to a greater extent, especially if you're not just repeating your lectures online, but you actually take advantage of the tools. And in fact, the whole experience under COVID has created a lot more experimentation and reduced the barriers that some teachers have had to take advantage of this. Healthcare, individualized medicine, all these things are going to create outcomes that, well, obviously have some economic implications, but the real benefits are measured in something else. There's a whole different world which is about dignity, which is, someone mentioned the right to be forgotten, how popular this is. This isn't about, this is about not being embarrassed by certain things or different aspects. And this is a much stronger notion in Europe. It really has been strongly shows up in U.S. law for the first time in the California Consumer Privacy Act, but it's in a number of other states that are moving forward. One thing I worry about, and I've actually got a paper I'm working on about this, which I've never, this is the first, you'll be the first to ever hear what I have to say about this, but there's a risk of the risk to be forgotten, the right to be forgotten is that it will lower the quality of the data. Why? Any bad information about you, it gives you the right to remove it. So the pool of data is not an honest pool. It's a pool that's been actually biased to take out bad information about individuals who care to exercise it. And that everyone else who's actually using that information then has to filter it through that assumption and understand that it's not, that it may hide some risks or some bad actors in ways that potentially render the fewer benefits to society because the data is less useful. So while the right to be forgotten is popular, as Elise said, if we look at it all through, there's a problem that it may not, there are some secondary consequences which aren't always taken into account. And there's a Supreme Court case called Sorrell versus IMS Health that raises serious questions about whether the First Amendment will prevent certain suppression of information sharing, of truthful information sharing in that way.
All right. We have I think we have about 7 minutes left, and we have a question from Shelly. She said that she read the privacy policy of a health insurer as she was trying to set up a portal to access information from a new medical provider. It said it collected information about my employment, personality, preferences, intelligence, geolocation, etc. None of this is covered by HIPAA, yet I suspect people who sign up for these portals have no idea that this is a trade-off for this service. How do we protect people from uses like this?
Kind of a perfect example of the trade-offs that we've been talking about. When you ask Americans about these kinds of portals, at least in the abstract, without necessarily going through all of the details that Shelly outlined, they love that they can interact with their doctors. a little bit more efficiently and more asynchronously. They don't have to play telephone tag. They can send in a query and they can get an answer back and they can schedule an appointment. And so there are ways in which the convenience of this is really compelling to people. But then there's all this other data combination, which also sort of fills in gaps in a really interesting way that Christopher was alluding to. You can draw lots more inferences about people once you get this much data about them. So you don't even have to have specific data points related to this. You can sort of watch patterns of movement and patterns of behavior and patterns of interaction, patterns of consumer behavior and things like that, and fill in the gaps. And this is the part that that Americans feel is sneaky, that I'm being profiled in much more elaborate ways than I was just under my credit score in the good old days. And they're really freaked out about the fact that they might be judged and assessed, and their worthiness is all bundled up in those new, robust, highly dense scoring systems.
Well, I guess my first thing that struck me, Shelly, when I read your question is to congratulate you for actually being one of the 10% that have read the policy all the way through based on what Lee says. What's fascinating, by the way, as an aside, there's a great literature on information markets that looks at what percentage of people have to read for it to actually have a positive effect in the world, because it's clear we don't all have to read the policies, in fact, and the estimates were actually right around 10%. And so it's fascinating to me that, Lee, the number you find is lining up right around there, because it suggests that that is an effective number for moving it into the general world of knowledge. So what's interesting to me is I do think that there's I understand the question Shelly's coming from, and there's things that are, to me, worrisome. I mean, one of the things that really struck me about your list, personality, is a fascinating one, which is, you wonder, is this important? I keep thinking about the new literature we're talking about now. Happiness is actually now a thing that health people are measuring. We're also measuring things like grit and other things that actually are deeply tied to long-term health consequences. And I find myself, thinking, maybe could we learn something from this, assuming that we get the purpose of the consumer, the patient's benefit clearly in focus. But to really zero in on one specific aspect about this that really struck me about Lee's data, people don't like mining your data to see if you're depressed. I will tell you, as an educator, one of the phenomena we're finding right now is we're spending a lot more time on detecting and helping mental health. And in fact, I've been told that this is a sign of the success of our mental health system. Students that used to not make it through college are now making it to graduate school because of the interventions we've been able to do, and to support them. All this is good. What it's meant is that we as a graduate school or professional school have devoted a lot more resources to identifying and supporting students who are in psychological distress. And in fact, we've got some training on how to detect this. I would love the idea of being able to help my students sooner, and if there's a better indicia or way for me to understand certain telltale signs. I mean, student absences, other things that I use now are easy, but there may be other things that we could do are potentially beneficial. At the same time, I understand that this is kind of creepy, in a sense, and not everyone wants that. And finding that balance, particularly when there are uncertain benefits to the potential interventions and we're still experimenting what they are, is difficult. My reaction is we should be able to deal with a lot of this stuff at the speculative level by requiring it to be anonymized, by requiring aggregation, because for the level of study that's needed, you can often use the traditional tools of research to make sure that it's not personally identifiable to any one person. And then we can actually make the assessment based on after it turns into therapies to actually decide whether, to the extent we allow it to go, be used.
All right, we have just a couple minutes left, and so I just want maybe just one quick comment on what the biggest lesson that legislators should have learned from the implementation of GDPR and CCPA. So in 30 seconds or less.
It's hard to put this stuff in a box. You're going to have to start punching holes in it relatively quickly.
I agree. I think there are always trade-offs. And in fact, it's hard because if you look at the studies, there's privacy absolutists, there's privacy don't care people, and privacy people in the middle. And so serving all of that is one thing, but also there is a trade-off between privacy and economics, privacy and public health, and privacy and COVID response. And the idea that we would always prefer one or the other isn't the answer. Giving ourselves smart heuristics of ways to think about this, to strike balances in the gray area in between, is the great challenge I think privacy faces. And I hope that my hope you take away from this is to engage that ambiguity as hard as it is, because that's the best way to serve your constituents.
All right. Well, we have run out of time. Both of you have been excellent, and this was very interesting and informative. For anybody on the webinar, if your answer did not get answered, if your question did not get answered, please send an email or put something in the chat and we will get back to you. I would once again like to thank our presenters. We greatly appreciate the expertise each of you was able to provide. And I would like to thank everybody who joined us today on the webinar. Have a great day and be safe.